Filing a divorce in Wisconsin isn't just about filling out a form and waiting for it to be over. It's a legal process, but also an emotional one. And if you miss just one important step, it could delay your case, hurt your financial future, and even impact your children. My name is Jeff Hughes, and I'm the lead attorney at Sterling Lawyer, and I will walk you through the 6 exact things that you need to do when filing for a divorce in Wisconsin. Whether you are initiating the divorce or responding to one, these steps will protect your rights, your finances, and your peace of mind. Let's dive in. Step number 1, confirm that you are eligible to file. Before anything else, you need to meet Wisconsin's residency requirements. One of you must have lived in Wisconsin for at least 6 months and lived in the county where you are filing for at least 30 days. It doesn't matter where you got married, it matters where you have lived. Unlike some states, Wisconsin is a no-fault divorce state, and that means that you do not need to prove abuse, cheating, or abandonment. You just need to be able to say that the marriage is irretrievably broken. Step number 2, get your forms in order. You need to file a summons and petition for divorce in the circuit court of your county. Also, if you have minor children, you need to fill out the parenting forms. Now, you can file jointly so long as both spouses agree to the divorce, or you can file individually and serve the other party. Most counties in Wisconsin allow you to download the forms online, but they still need to be filed in person or electronically online with the court. And there is a filing fee, and that is usually around $200, and it varies slightly depending on the county. Step number 3, serve the papers if you are not filing jointly. Now, if you're filing individually, you must legally notify your spouse. Now, that means serving them with the divorce papers, and you can do that one of a few ways. You can use the sheriff of your county, or you can use a professional process server, or you can give the paperwork to them and have them sign a document called an admission of service indicating that they received the documentation. Do not just hand them the paperwork. If it is not done properly, your case will likely get delayed and even thrown out. Also, you should know that once your spouse is served, they have 20 days to file a response with the court. I recall a case once with a fellow named Kevin. He filed the paperwork and then he handed the paperwork to his spouse at a family barbecue. It felt civil until the court later rejected his service, and he had to restart the process all over months later. And we helped him file his case correctly and get his matter back on a proper timeline, but the delay was completely avoidable. Step number 4, prepare for at least a 120-day waiting period after the service. Once the summons and petition is filed and served, the court then requires a 120-day waiting period before the divorce can be finalized. Now, that gives both parties time to negotiate parenting, support property division, and all the issues pertaining to divorce. You can also attend mediation during that time if that is appropriate, or you may even have a temporary order hearing which sets short-term rules like custody and placement, support, who lives in the house and so forth, and who pays the bills. During this time, so much can happen. This is when most cases are negotiated and resolved. And for those cases that are not settled through negotiation, this is when all the facts are built up for a later contest in front of the judge known as a trial. Step number 5, know what you are dividing and how. Wisconsin is a marital property state, and what that means is that all property in the marriage starts with an assumption that it is marital to be split 50-50 at the time of divorce, no matter whose name is on the title or on the account. Now, that's the starting assumption, and it can be deviated based on the judge's discretion. Now, you should know that includes all houses, real estate, property, retirement accounts, vehicles, debts, personal property items. Unless you have a clear and valid prenuptial agreement, only gifts and inheritances are the things that might stay separate, and only if they were never mixed with marital funds. So start gathering all the documentation right now, and that means bank statements, pay stubs, titles, tax returns, and valuations. That gives you negotiating power later on. Another case comes to mind with this client named Janelle, and she assumed that she'd get to keep her retirement account since Marcus never contributed. but it was funded during the marriage, so it's split right down the middle. So having a detailed paper trail of what's marital versus separate can make a world of difference. Step number 6, prepare for final negotiations, mediation, or the final hearing. If you and your spouse agree on everything, parenting time, child support, spousal support, property division, you can finalize it all through a stipulated marital settlement agreement. If not, you will go to mediation and in some cases, even a trial in front of the judge. Now, if you have a full negotiated agreement, the final hearing is usually about 30 minutes long, and assuming it's done correctly, the judge approves the agreement and it becomes the permanent part of the judgment of divorce. So whether you're going to a full negotiated settlement hearing or to trial, the key is preparation. If you're going to a trial, you'll need much more. You'll need all of your exhibits, your financial disclosure statements, and your proposals to the court that will include your parenting plan, what should happen with the children if you have minor children, and it should include your proposed division of your assets and your debts. Now, what happens after the divorce is final? Well, first, you cannot remarry for 6 months anywhere in the world, not just in the state of Wisconsin. Your divorce decree becomes public record unless it is sealed by the court, and that is rare. And all of the orders that are included in the judgment of divorce also become effective. Now, that could be child support, child custody and placement, alimony, property, and debt division. That all becomes effective on the day of divorce. Now, filing is one thing, but what if you did not choose this? What if they filed for the divorce and you are not ready? You still have options, but the timing and your first moves matter more than you think. In our next video, I will walk you through exactly what to do if your spouse wants a divorce in Wisconsin and you don't, before it's too late to protect your future. Click below and I will see you there.